Don't say a word to your mother-in-law. That was the text. 5 words from a number I didn't recognize, sent at 6:47 in the morning while I was still in my hotel room in Scottsdale, Arizona, watching the desert light come through the curtains. I'd been there for a conference, 3 days of continuing education credits for my CPA license, the kind of thing my firm required every 2 years. I was supposed to fly home the next morning. I had already packed half my suitcase. I stared at the text for a long time. My first instinct was to call my mother-in-law. That's how deep the habit ran. Even then, even after everything. For 11 years I had been married to her son, and for 11 years she had been the one I called when something strange happened, when the pipe burst under the kitchen sink, when the car made that sound, when I got the call that my husband Evan had collapsed at the gym and they were taking him to St. Luke's. She was the first person I called that morning too, and she picked up before the second ring. Evan died on a Tuesday in March, 14 months before that text arrived. He was 41. A congenital heart defect nobody had known about, the kind that hides behind a normal EKG and only shows itself when it's already too late. We had been married for 11 years. We didn't have children, we'd been trying, and then we'd stopped trying, and then we'd talked about starting again, and then he was gone and there was nothing left to start. His name was Evan Mercer, and what his mother did after he died is the reason I'm telling you this story. Her name is Lorraine. She is 63 years old. She lives in a 4-bedroom house in Naperville, Illinois that Evan's father left her when he passed, and she has a way of speaking to people that makes them feel like they've already made a mistake before they open their mouths. I know that sounds harsh. I spent 11 years trying to reframe it as direct or practical or just her way. I'm done reframing it. For the first 3 months after Evan died, Lorraine was at my house almost every day. I thought it was grief. I thought she needed to be in his space the way I needed to be in his space. Touching the things he'd touched, sitting in the chair he'd sat in. I let her have a key. I made her coffee. When she cried, I held her hand, even when I was the one who needed someone to hold mine. What I didn't know was that Lorraine had begun making calls. Not grief calls. Not the calls you make when someone you love dies and you need to hear another voice. She was calling Evan's attorney. She was calling the financial advisor. She was calling the bank where Evan and I had held our joint accounts, and the insurance company that held his life insurance policy, and the HR department at the company where he'd worked for 9 years. I found out about all of this later. At the time, I just noticed that she started asking questions. At first, they seemed like normal questions. Did I know where Evan kept his files? Did I know which email account he used for financial stuff? Did I have the login for the brokerage account? I answered all of them. I was in the fog that descends after sudden loss, the kind where every day feels like moving through wet concrete, and I was grateful that someone else wanted to handle the practical things. I was grateful, and I was stupid, and I was 29 years old, and I had never had to think about any of this before. What I should have recognized, what I understand now, years later with the clarity that only comes after you've been burned, is that Lorraine wasn't helping me manage the estate, she was managing me. Evan's life insurance policy was worth $800,000. He had named me as sole beneficiary. He had also, separately, set up a revocable living trust 18 months before he died. Something his attorney had recommended when we'd started talking about buying a larger home, and that trust held the equity from the sale of his previous condo, a brokerage account with roughly $340,000 in it, and the deed to a small rental property in Indiana that he'd inherited from his father's brother. The total value of the trust was somewhere around $580,000. I didn't know the trust existed. That's the sentence that still catches in my throat when I say it out loud. I didn't know. We were married. We talked about money, not in great detail, but we talked about it. I knew about the brokerage account in a general way. I knew about the rental property because we'd visited it once, driven past it on a road trip, and Evan had said something vague about it being an asset. But I didn't know he'd formalized all of it into a trust. I didn't know there was a document. I didn't know that the document named me as the primary beneficiary and Lorraine as the contingent beneficiary, meaning she would receive everything in the trust if I was not available to receive it. Not if I died. If I was not available. The attorney who drafted the trust later told me that Evan had chosen that language deliberately, meaning it was intended to account for a scenario where I was incapacitated or had predeceased him. It was not intended as a loophole. It was sloppy drafting and an honest mistake. But Lorraine had read that document. I don't know when or how she got her hands on it, but she had read it. And she had seen the word available, and she'd begun to think about what it might mean. I'm getting ahead of myself. Let me go back to Scottsdale. I was standing at the window of my hotel room at 6:47 in the morning, holding my phone, looking at 5 words from a number I didn't know. Don't say a word to your mother-in-law. I had a cup of coffee going cold on the desk behind me. My flight home was tomorrow. I had a presentation in 2 hours on updated depreciation schedules under the Tax Cuts and Jobs Act. I typed back, "Who is this?" The reply came in less than a minute, "Someone who knows what she's been doing with Evan's estate. Call this number from a private line when you're alone." And then there was a phone number with a 312 area code. Chicago. I sat down on the edge of the bed. I want to be honest about what I felt in that moment because I think it matters. I didn't feel fear. I didn't feel the dramatic spike of adrenaline you'd expect from a scene like this. What I felt was something slower and heavier, a kind of dread that was already halfway familiar, like a word you almost recognize in a language you've almost forgotten. Some part of me had already known that something was wrong. I just hadn't let myself look directly at it. I called the number from the hotel landline during my lunch break, sitting in a corner of the lobby with my back to the wall. The man who answered said his name was Philip. He was Evan's second cousin, a branch of the family I'd met exactly twice, at a funeral and at a reunion, people who existed at the edge of my awareness of Evan's life. But Philip had been close to Evan's father, and when Evan's father had died, Philip had been the one to help organize the estate. He knew how that family worked. He knew Lorraine. He told me that 4 months after Evan died, Lorraine had contacted the trust's successor trustee, a provision in the document that allowed her to petition for a change in trustee status if the primary trustee was unable to fulfill their duties. The primary trustee was supposed to be me. Lorraine had submitted paperwork claiming that I was emotionally incapacitated and unable to manage the trust's assets responsibly. She had gotten 2 signatures to support this claim. One was from a neighbor. The other was from a doctor, not my doctor, not anyone who had ever treated me, who had signed a letter that Lorraine had apparently drafted herself and presented to him under circumstances Philip described as not entirely clear. The trustee had been changed, not to me, to Lorraine. I had to put the phone down for a second, not because I was going to cry, because I needed to think. I picked it back up. "What has she done with the assets?" I asked. There was a pause. "That's what I've been trying to figure out," Philip said. "The rental property in Indiana was listed for sale 6 weeks ago. It sold last month. I only know because I drive past it sometimes. The sign was there and then it wasn't. The rental property had been worth approximately $210,000. I thanked Philip. I told him I would handle it. I hung up and I sat in that hotel lobby for another 20 minutes, not moving, doing math in my head. Then I called my firm. I have been a CPA for 8 years. Before that, I spent 3 years working in forensic accounting for a litigation support firm in downtown Chicago. The kind of place that gets called in when a company suspects someone in their finance department has been skimming, or when a divorce gets ugly and one spouse is convinced the other has been hiding assets. I am not a dramatic person. I don't like conflict. I once let a contractor overbill me by $400 rather than have the confrontation. But I know what financial fraud looks like. I know how to trace it. And as I sat in that hotel lobby in Scottsdale, realizing that the woman I had held while she cried over my husband's grave had spent the past year systematically looting his estate, something went very quiet inside me. Not angry. Quiet. I've learned to pay attention to that feeling. I did not fly home the next morning. I changed my flight, called my supervisor, told him I had a family emergency, which was accurate, and spent the rest of the day on my laptop in my hotel room, pulling every document I could access. I had Evan's social security number. I had his date of birth. I was still his surviving spouse. I pulled the trust document from the county recorder's office website. I pulled the property transfer records for the Indiana rental. I found the sale listing on a real estate aggregator site, listed by a brokerage in Merrillville, Indiana, closed 4 weeks prior, sale price $218,500. The deed transfer listed the seller as the Mercer Family Trust. The trustee's signature on the closing documents was Lorraine Mercer. I flew home on Thursday. I did not text Lorraine to tell her I was back. I did not call her. For the first time in 14 months, I did not reach out to her at all, and the silence felt like taking off a coat I hadn't realized was soaking wet. I called an estate attorney on Friday morning. Her name was Sandra. She had been recommended to me by a colleague, and she had a manner that reminded me of a very calm, very organized surgeon. Someone who had seen worse than this and knew exactly which instrument to reach for. I spread my documents across her conference table and walked her through everything I had found. She was quiet for a moment when I finished. Then she said, "The trustee change was fraudulent. The documentation supporting your incapacitation claim is almost certainly forged or obtained under false pretenses. The sale of the Indiana property without your knowledge or consent was a breach of fiduciary duty. And depending on what has happened to those sale proceeds, we may be looking at criminal exposure. How long will this take?" I asked. "Longer than you want," she said. "But you have a strong case. I want to tell you that I felt relief in that moment. I didn't. What I felt was tired, the bone-deep tiredness of someone who has been holding something heavy for a long time without realizing it. Because the truth is that the last 14 months, which I had experienced as grief, had also been something else. They had been a slow, careful process of being managed and handled and positioned, and I hadn't seen it because I was too sad to look. Lorraine had been in my house every week. She had helped me sort through Evan's clothes. She had cried with me over his coffee mug, the one with the faded Chicago Bears logo he'd had since college. She had sat at my kitchen table and told me that I needed to take care of myself and not worry about the financial stuff right now, and let her handle things for a while, and I had let her, because I was 29 and newly widowed, and I had no idea that the woman handing me tissues was simultaneously filing paperwork to strip me of my legal rights as a beneficiary of my husband's estate. The litigation process took 7 months. I won't walk you through every filing, every deposition, every conference call with Sandra, where I had to listen to Lorraine's attorney argue that my grief had genuinely rendered me incapable of managing financial decisions. I will tell you that there were moments where I sat in rooms and listened to things being said about me, about my mental state, my stability, my fitness as a trustee, and I had to keep my face perfectly still because the alternative was to say something that would not help my case. The doctor who had signed Lorraine's incapacitation letter turned out to be a retired physician from her church who had met me exactly once at Evan's wake. He had signed the letter, he testified, because Lorraine had told him I had asked for help and was too embarrassed to ask directly. He had not examined me. He had not spoken to any of my actual physicians. He had signed a letter that called my mental competence into question based on a 20-minute conversation at a funeral home, and Lorraine had used that letter to remove me from the trust. The neighbor, who had also signed the letter, recanted during her deposition. She said Lorraine had told her it was a routine administrative document and that my signature was on it too. Mine was not. The proceeds from the Indiana property sale, $218,500, had been deposited into a bank account in Lorraine's name alone. Sandra's forensic review of the account showed that $47,000 had already been disbursed. Some of it had gone to what appeared to be home renovations. Some of it had gone to a travel account. One transfer for $12,000 had gone to a LLC whose registered agent was Lorraine's sister. We filed a civil suit for breach of fiduciary duty, fraud, and conversion. We also referred the matter to the State Attorney General's office, which has a financial exploitation unit that deals specifically with elder financial abuse and estate fraud. Given that I was the surviving spouse and the named beneficiary and the rightful trustee, and given the documented evidence of forged or fraudulently obtained signatures, they took it seriously. Lorraine hired 3 different attorneys over the course of the litigation. The first one withdrew after 2 months. The second one billed her at a rate that I suspect significantly reduced whatever financial cushion she had been building. The third one negotiated the settlement. The settlement required Lorraine to return the full $218,500 from the sale of the Indiana property, plus interest. It required her to relinquish any claim to the trust now and permanently. It required her to pay a portion of my legal fees. And as part of the referral to the Attorney General's office, she entered into a consent agreement that included a $25,000 civil penalty and a 5-year prohibition on serving as a trustee or executor of any estate in the state of Illinois. She did not go to prison. I want to be honest about that. There was a period, a longer period than I'm proud of, where I wanted her to. Where I would lie awake at night and calculate sentences and think about what it would look like for her to be in a room with bars on the windows, the way I had sometimes felt in my own home with her sitting across from me at my kitchen table. She didn't go to prison, but she lost. And there's something about that, about the particular quality of that kind of losing, where everything you tried to take is taken back, where the document you forged becomes the evidence against you, where the scheme collapses under the weight of its own paper trail, that I have come to understand is enough. It's enough, it has to be. I have Evan's trust back. The brokerage account reconstituted. The rental property in Indiana was gone, but I have the proceeds with interest. The life insurance I had always had. Lorraine had never been able to touch that, because my name was on it in a way that didn't require any trustee to cooperate. I sold the rental property proceeds and used part of them to buy a small condo near my office in Chicago. I framed Evan's coffee mug, the Bears one, and put it on the shelf in my living room where I can see it from the couch. I kept his last voicemail on my phone for 2 years, and then one morning I deleted it, not because I stopped loving him, but because I didn't need it anymore to remember what his voice sounded like. I am 32 now. I have a job I'm good at. I have savings. Finally, after a year of being afraid to look at my own bank accounts because I was never sure what Lorraine had or hadn't interfered with, I have a new attorney who reviewed every financial document I own and confirmed that everything is in order. I have Philip's number in my phone. We have lunch sometimes, and he always orders the same thing, a club sandwich with no tomato, and last time he told me cleans later. I think he was right. I think about what it took for me to become someone who could do what I did, pull those records, make those calls, sit in those rooms with my face still while someone described me as emotionally incapacitated. I spent 3 years training to trace financial fraud. I spent 11 years being underestimated by the woman across the table from me, and I spent 14 months being so deep in grief that I almost missed what was being built around me. Almost. That text message came from a prepaid phone Philip had bought specifically to reach me, because he didn't know if Lorraine had access to my regular phone records, and he didn't want to risk it. He thought about it for 3 weeks before he sent it. He told me later that what made him finally do it was seeing the for sale sign go up on that Indiana property. He said something shifted when he saw it, some internal calculus that told him enough. I know that shift. I felt it too, sitting on the edge of a hotel bed in Scottsdale while my coffee went cold. Evan used to say that the problem with people who steal quietly is that they count on the people they're stealing from to be too polite to notice. He said it about a client, years ago, someone who had discovered their business partner had been siphoning funds for 3 years before anyone looked closely at the numbers. I remember thinking at the time that I would always look closely, that I was not the kind of person who could be counted on not to notice. He was right about me, he always was. I noticed, I looked closely, and when I did, I found exactly what I was trained to find. A paper trail leading right back to the beginning, as clear and irrefutable as a line on a ledger, waiting for someone to follow it home.